Be ready for dictation. 5 seconds to go. Start. The explanation to Section 6A3 stipulates that the opinion of the tribunal constituted under the Foreigners Tribunal's order declaring a person to be a foreigner is deemed as sufficient proof for requirement. Whether the person satisfies the other requirements must be decided on the basis of the opinion of the tribunal. If there is a finding in the opinion with respect to that requirement, if the opinion does not have a finding with respect to the other requirements, the registering authority must refer the questions to the tribunal. Section 6A4 states that if the person who has registered under subsection 3 is included in the electoral roll for any assembly or parliamentary constituency, their name must be deleted from the roll for a period of 10 years from the date of detection as a foreigner. However, a person who has been registered will have the same rights and obligations as a citizen of India except having their name included in the electoral roll for 10 years. They will also have the right to obtain passport under the Passport Act 1967. Upon the completion of 10 years from the date of detection as a foreigner, a person who has registered would be deemed to be a citizen of India. The petitioners initiated proceedings under Article 32 of the Constitution inter alia for challenging the constitutional validity of Section 6A of the Citizenship Act by an order dated 17 December 2014. A two-judge bench of this court referred 13 issues to a constitution bench. On 13 December 2022, the constitution bench directed the council to jointly formulate issues which arise for the consideration of the bench. On 10 January 2023, the Constitution Bench framed the following primary issue for determination whether Section 6A of the Citizenship Act suffers from any constitutional infirmity. The provision on conditions for acquiring citizenship after the commencement of the Constitution, that is, the second clause in the memorandum, was not included in the draft Constitution of India 1948 submitted by the drafting committee on 21 February 1948. The draft constitution only included provisions on who would be citizens on the date of the commencement of the constitution and granted parliament the power to make provision on acquisition and termination of citizenship and all other matters relating thereto. Article 5 of the Draft Constitution 1948 included provisions for refugees from East and West Pakistan. Clause B of Article 5 provided that every person who or either of whose parents or any of whose grandparents were born in India as defined in the Government of India Act 1935 or in Burma or Ceylon and who is domiciled in the territory of India as defined by the Constitution will be a citizen upon the commencement of the Constitution, provided that the person has not acquired the citizenship of any foreign state. The explanation to the provision stated that a person is deemed to be domiciled in the territory of India on depositing a declaration to acquire such domicile after having resided for at least 1 month in the territory of India. According to the explanation, the declaration had to be deposited before the commencement of the constitution. Thus, migrants from East or West Pakistan to India could be citizens by virtue of Article 5B of the draft constitution if they submitted a declaration after having resided in India for a month. Dr. Ambedkar, as the chairperson of the drafting committee, introduced amendments to draft Articles 5 and 6. He further introduced Articles 5A, 5B, and 5C, which provided separate provisions for migrants to acquire citizenship. While introducing these amendments, Dr. Ambedkar noted that the object of the above provisions was not to lay down a permanent law of citizenship, but to decide who would be citizens as on the date of the commencement of the Constitution. The drafting history of the provisions on citizenship elucidates that after extensive deliberation in the Constituent Assembly and the drafting committee, it was decided that the Constitution would only stipulate who would hold citizenship on the commencement of the Constitution. This is also clear from the language and the substantive portions of the provisions included in Part 2 of the Constitution, which deals with citizenship. तो ये आपकी डिक्टेशन फिनिश हुई। डिक्टेशन काफ़ी अच्छी है, इसे लिखिए और ट्रांसक्राइब करिए, ज़्यादा से ज़्यादा लोगों को शेयर करिए ताकि वो भी इसको लिख सकें। ये डिक्टेशन काफ़ी हेल्पफुल होगी आने वाले एग्ज़ाम्स के लिए, लाइक सुप्रीम कोर्ट, पीए एंड सीनियर पीए। थैंक यू।